And we are here now this afternoon to hear case 29491, Malcolm Byrd versus Lindsay Corp. Each side will have 15 minutes to present its argument. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and you do plan to reserve time, let me know when you begin your argument. I'll be monitoring the clock. I will do my best to try to keep you apprised of when you're approaching your rebuttal time. These arguments are being visually and audibly recorded. They will be posted on YouTube. I would warn you not to use the names of children and victims, but that's not applicable in this case, so I think we need to worry about that. We have read your briefs and we are ready to proceed when you are. Ms. Riney, you are the appellant in this case, representing Lindsay Corp. And then Mr. Palick, you would be representing Mr. Durkos in this matter, who is I guess I'll call him the non-party subpoena, I guess would be probably the best way, but we will go ahead and proceed.
Good afternoon, Your Honor. May it please the court. My name is Shelby Riney. I represent Lindsay Corporation, the appellant in this case. And I would like to reserve 3 to 5 minutes for rebuttal, please.
Which one?
Probably closer to 3, Your Honor.
Okay.
Depending how quickly I speak.
All righty. Whenever you're ready.
Thank you. This case involves guardrail end terminals, which are road safety devices attached to the blunt end of a guardrail to reduce the risk of serious injury or death when a vehicle departs the roadway and strikes a guardrail. Guardrails and guardrail end terminals are in and of themselves roadside hazards. This is widely accepted and acknowledged in the roadside safety community, including by the Federal Highway Administration and state departments of transportation. While crash testing conducted on guardrail end terminals is representative of approximately 97% of highway crashes, there are impact conditions that exceed the performance expectations of all vehicles and all guardrail end terminals. Therefore, simply because a vehicle departs the roadway, crashes into a guardrail end terminal at 70 miles per hour, and a passenger in the vehicle is seriously injured or killed, that in and of itself does not prove that there is a design defect with the guardrail end terminal. Yet, in this product liability action, this is precisely what the plaintiff must prove: that the death of Wilbert Byrd was the direct and proximate result of a design defect with Lindsay's X-Lite guardrail end terminal. Lindsay knows, based on discovery to date and expert disclosures, that plaintiff will attempt to prove a design defect with X-Lite by offering evidence and argument that because state departments of transportation took certain action against X-Lite after Wilbert Byrd's crash, that they have determined that X-Lite is defective, and therefore a jury should too. In the year and a half since Lindsay served its subpoena on Mr. John Durkos, discovery has been ongoing and expert disclosures have been served, all of which demonstrate that plaintiff intends to argue at trial that state departments of transportation took action against X-Lite because it is defective. However, this characterization is misleading and an oversimplification of the issue. In fact, approximately 1 year after Mr. Byrd's crash, the Federal Highway Administration examined the most rigorous in-service performance data collected as of that date, which included crash data involving all guardrail end terminals on the market across 4 states. And the FHWA determined that the data does not lead to any conclusions that the Lindsay X-Lite is unsafe.
Counsel, wouldn't it be better or more productive, more appropriate to seek that information directly from the departments of transportation as to why they made the decisions to not use Lindsay's product?
Your Honor, one of the reasons why I provided you with this background is to provide the context of the industry. And various state departments of transportation have taken action really succumbing to political pressure, even though the data in their particular states does not indicate any issue with the X-Lite specifically or any other guardrail end terminal. Instead, many of them have responded to the enormous pressure exerted on them by someone by the name of Stephen Eimers in particular, a bereaved father from Tennessee. And really key to that issue is not just what Mr. Eimers was saying to state departments of transportation and what information he had provided that informed their decisions, but that behind the scenes, John Durkos, an employee of one of Lindsay's only 2 competitors in the guardrail and terminal market, was aiding Mr. Eimers.
Counsel, follow up with that.
Yes.
Why does that matter? Let's say he did. If you're trying to demonstrate that all these state departments of transportation basically acquiesce to political pressure, what does it matter who is giving the information out? Because the whole point is, how would they know if they're acquiescing to the gentleman that the daughter died? I can't think of his name right now. Mr.
Stephen Eimers.
Mr. Eimers. How would Mr. Darkos know, or how could he shed any light on whether the employees of the state departments of transportation are doing it based on political reasons? They could only answer that question.
Well, Your Honor, it goes to the credibility of the evidence that plaintiff will seek to introduce at trial, because while this accident happened in Tennessee, certainly there will be representatives of the Tennessee Department of Transportation who may offer testimony. Plaintiffs seek to introduce evidence of actions taken by states other than Tennessee. So it'll be plaintiff telling the jury, no, these state departments of transportation took action against X-Light because they think it's defective. If plaintiffs permitted to make this argument in an attempt to prove a defect with X-Light, again, based upon decisions by state departments of transportation, then the jury should also have the benefit of learning that the state departments of transportation took action following extreme political pressure from Mr. Eimers, who received support from Lindsay's direct competitor. Again, it goes to the credibility of arguments made by plaintiff to the jury.
But why can't you just ask? Why can't you depose the director of the Department of Transportation for each state? Why can't you have them at trial and ask them that question?
Well, Your Honor, again, with respect to every other Department of Transportation or any other Department of Transportation that plaintiff will argue took action against X-Light for reasons that they determined it was defective, even if it does not say that in the letter in which they stated that X-Light was being removed from their qualified products list. First of all, those states are not parties to this litigation. So even if Lindsay could issue a subpoena out of state to request multiple State Department of Transportation officials to testify, this evidence that Lindsay seeks from Mr. Durkos goes to the credibility of any testimony they may provide. Most State Department of Transportation officials, irrespective of what's happening behind the scenes, I don't think that they are going to very willingly or eagerly, say, yes, we took this action because a bereaved father applied pressure on us. And so Lindsay should be permitted, to the extent that plaintiff, again, offers this evidence to argue to the jury that State Department of Transportation actions prove X-Light is defective, Lindsay should be permitted to discover information that undercuts that argument and shows that not only were State Departments of Transportation being pressured by a bereaved father, but the information that he was providing to State Departments of Transportation to inform their decisions came from a direct competitor.
Well, counsel, let me flip this around a different way. Is Tennessee law, I assume, such that the burden's on the plaintiff here, correct?
Correct, to prove design defect, Your Honor.
Thank you. And you're suggesting that the plaintiff in this case can prove a design defect by these supposed subsequent actions that have happened by the Departments of Transportation?
Your Honor, Lindsay, as the defendant, vigorously contests that would be sufficient to prove design defect in this case. Nevertheless,
and you've suggested that you have or are going to file a motion in limine, correct?
Certainly, Your Honor. However, with respect to discovery, we know for certain, both, again, based on discovery today and what is in plaintiff's expert disclosures, they intend to make this argument.
Well, of course they do. They're the plaintiffs.
And the Tennessee court, Your Honor, as we mentioned in our brief, We also served a subpoena on RSI in Texas. And in order to accomplish that, we had to go directly to the Tennessee court to request that it issue a commission allowing us to serve the subpoena on RSI. And during that hearing, plaintiff's counsel argued that we should not be permitted to issue the subpoena because the information sought was irrelevant to the Tennessee action. Nevertheless, the Tennessee court allowed the issuance of the subpoena to RSI over plaintiff's relevancy objections, and that Texas court allowed discovery from RSI.
Are you suggesting that Ohio should be bound by the Texas court?
Certainly not, Your Honor. It's just that the Tennessee court, with the broadest idea of what's happening in this litigation, the arguments made by plaintiff's counsel in the briefing, by the expert disclosures, and that understands the issues in this case, allowed the service of the subpoena over relevancy objections. And primarily, that is what Mr. Dirkos has contested here. And it appears to me that the decision of the lower court turned on its view that Lindsay was speculating, and I'm quoting, as to what affirmative evidence plaintiff would seek to introduce at trial, namely the actions taken by certain state departments of transportation. Not only is that factually inaccurate, again, as I just mentioned, we know through discovery and expert disclosures, they do intend to offer this evidence, but that's not the standard for discovery under Ohio law. The standard is whether the information sought is relevant to the subject matter, which is whether it's relevant to a claim or defense of the party seeking discovery. Nowhere do the Ohio rules require that the defendant must first prove that the plaintiff will affirmatively offer particular evidence at trial to prove its case before the defendant may discover evidence critical to its defense at trial. The facts here are similar to those in McDade versus Morris, where this court appropriately permitted discovery of evidence that would be relevant to countering anticipated arguments made by a party at trial.
But the whole point is, even with that argument, the critical term is relevant. And so the way I read the court's order was it just didn't feel that it was relevant to even if that argument is made. Because what does it really matter who gave them the information? All it matters is, did they act on the information, or did they act on the fact that they had come to the conclusion that there was a defect in the guardrails? So what does it matter who the information came from?
Your Honor, that goes to the credibility of the information and the concerted effort taken by Mr. Dirkos, by Mr. Eimers, and by the plaintiffs in this case to sway the actions taken by state departments of transportation. Indeed, as mentioned in our briefing, the web between Mr. Eimers and Mr. Dirkos is so intricate that Mr. Eimers is represented by the same plaintiff's counsel that represents Mr. Byrd's estate, and the plaintiff has retained as its product design expert the designer of RSI's guardrail and terminal sold by Mr. Dirkos and in direct competition with X-Lite. So, Your Honor, we would maintain that it's directly relevant to the question of who's providing what information and for what purpose.
But you know that already, don't you? I mean,
based on
you
information,
know that.
My apologies, Your Honor. What was that?
I said, you know that. You have it all mapped out, that web. If in fact, and I don't want to say much because you're right at your 3 minutes, so I'm going to pause this, but if you were to find out that one department of transportation didn't make a decision based upon, let's say, safety testing, but succumbed to this pressure, you have this whole mapped out web of who's interspersed and interlocked with who. You already have it.
We do have the web, Your Honor, but we need additional information. And to very quickly touch on the other issues.
Hang on. You're into your time already. I'm sorry.
Okay. Thank you, Your Honor.
Save that for rebuttal. All right. Give me 1 minute here. And Mr. Palick, when you're ready.
May it please the court, counsel. My name is Evan Palick, and I am proud to represent the Appalachia and Summit County resident, John Dirkos, in this matter. The trial court granted Mr. Durkos motion for protective order and motion to quash, and we firmly believe that the trial court's decision was correct. However, that is not the question that needs to be asked by this court. This court needs to determine the standard of review. And in this particular case, the standard of review for the trial court's decision is an abuse of discretion. So if this court finds that the lower court abused its discretion, then this court certainly has the ability to reverse. However, if this court determines that the trial court did not abuse its discretion, then the trial court's decision should be affirmed. And there's several descriptions of what abuse of discretion is. And there's case law that basically says that abuse of discretion implies that the court's attitude is unreasonable, arbitrary, or unconscionable. There's also, I think, the Huffman case from the Ohio Supreme Court, which really, I think, lays out just how high a bar abuse of discretion is. And it basically says that the result must be so palpably and grossly violative of fact and logic that it evidences not the exercise of will, but the perversity of will, not the exercise of judgment, but defiance thereof, not the exercise of reason, but rather of passion and bias. So I think the Supreme Court is telling us that an abuse of discretion is a very high hurdle for the appellant to get over for this court to reverse the trial court's decision. Now, what I think is important to stress here, and some of the case law cited by the appellant talks about various instances where courts have found abuse of discretion in rare instances. But in this particular case, we should look at exactly what the trial court did in ruling on this request for protective order and quash the subpoena that was issued to him by the appellant. In this particular case, the trial court received, analyzed, and independently reviewed the magistrate's decision, and the magistrate actually had an extensive briefing and oral hearing. The trial court did an independent review and analysis of the issues raised and the applicable law. So here we have a situation where this was not a very quick decision, an arbitrary decision by the trial court. This was a decision that came to through extensive analysis and review of the evidence before the trial court, the magistrate, and ultimately the trial court.
What was the court's analysis on undue burden?
Well, the undue burden, I believe, was demonstrated by the affidavit that Mr. Durkos provided to the trial court. And the affidavit basically said several things, but one of the things that Mr. Durkos did say was that the information requested by the appellant, Lindsay Corporation, includes confidential documentation and correspondence. Lindsay has asked for internal communications within RSI, Durkos' employer and competitor of Lindsay, as well as communications between RSI and third parties. In addition to the request of being unduly burdensome, they demand the production of proprietary materials and would require RSI and Mr. Durkos as its employee to disclose trade secrets. RSI is a leading manufacturer of guardrails that are at issue in the Tennessee litigation, and RSI is a direct competitor of Lindsay Corporation. So I believe—
Mr. Palick, in fairness, they modified the initial subpoena and made it pretty clear that that's not what they were after, correct?
Well, they did limit the original requests in the documents, but the document still requested a significant amount of information that the trial court still believed was burdensome and overreaching, and asking this particular deponent to disclose information that was clearly not relevant, and clearly plaintiff appellant failed to show a substantial need for the information that it was requesting. And I think some of the questions that were posed to my appellant's counsel regarding what happened or what's available to the appellant to get this information. And I think it's critical, and the trial court clearly pointed out that the appellant can get this information from other sources, namely from the Department of Transportation of Tennessee, Nebraska, Virginia, I think New Hampshire, all the different states that have actually analyzed this guardrail and made a determination that this guardrail might not be safe, and so they've taken it off their qualified products list. That information, I think, is clearly available to the plaintiff, and it doesn't have to come from my client, who is a competitor of the appellant. And I believe the request is overly broad and just asks for information that would clearly be unduly burdensome. Clearly, I think the trial court was correct in determining that this is nothing more than a fishing expedition. And I think that also was telling that the trial court, I think, also appropriately noted was the correspondence from appellant's counsel, Mr. Heller, to RSI, my client's employer, that basically threatened litigation in the letter dated September 26, 2018, which I believe is in the record. The attorney says some of the communications we have seen may constitute tortious interference with business relations, trade, libel, and other unfair competition. So I think what's really going on here, and I think the trial court appropriately noted, is this is a fishing expedition trying to get information from a competitor of the appellant, and in the hopes of possibly getting this information. They claim that it's to defend this products liability suit in Tennessee, but that doesn't pass the smell test. I think what's really going on here is a fishing expedition to get to the information that my client has and possibly use against him in some kind of future lawsuit. So I believe the record demonstrates quite clearly that the trial court below did not abuse its discretion. They found, the trial court properly found that the subpoena was asking for information that's not relevant to the litigation in Tennessee. The plaintiff has not shown a substantial need for this information it's requesting. I believe the trial court's decision was clearly proper after an independent review and analysis of the record below. And even if, as I said at the beginning, even if this court may disagree with what the trial court did, that is not justified reversal of the trial court's decision. The trial court's decision should be affirmed because it clearly did not constitute an abuse of discretion. So I would ask that the trial court this court affirm the trial court's decision and not force my client to turn over this information that the appellant is seeking in its subpoena. Thank you.
All right, thank you. Ms. Riney, you have your 3 minutes remaining.
Thank you, Your Honor. First, the lower court acted arbitrarily when it determined that the only reason Lindsay sought documents from Mr. Durkos was to discover trade secrets. As Your Honor mentioned, Lindsay modified its subpoena to make clear it is not seeking RSI's trade secrets. Rather, the subpoena was targeted toward uncovering the concerted effort by Mr. Eimers and Mr. Durkos to influence state departments of transportation. That's why it's limited now to communications between Mr. Durkos and Mr. Eimers, and documents and communications that Mr. Durkos had with third parties about Lindsay and or the X-Lite. Again, meaning that trade secrets would not be included in these communications. Moreover, the trial court erred when, instead of requiring Mr. Durkos to prove that complying with Lindsay's subpoena and producing documents in response to the limited request would impose an undue burden on him, instead, the trial court shifted the burden to Lindsay to prove substantial need. Now, Mr. Durkos failed to offer any evidence of undue burden. If his affidavit says merely that it would impose an undue burden on him, that's all that it says. He failed to articulate any facts or circumstances that would demonstrate what that undue burden is.
Well, before you get to undue burden, wouldn't you have to look at relevancy though?
You would, Your Honor, and as we have discussed, the information Lindsay seeks is relevant to underlying litigation and the issue of design defect and the manner in which the plaintiff intends to argue to the jury that X-Lite is defective. Again,
In other words, it's relevant to your defense.
Yes, Your Honor, thank you. And again, the lower court erred by saying that effectively that Lindsay had to prove to the court that plaintiff would in fact offer evidence of State Department of Transportation actions to prove design defect before Lindsay would be permitted to discover evidence that it could use to counter this evidence. Nowhere in the Ohio rules is that stated. It says that a party may discover evidence relevant to a claim or defense. Lindsay maintains this is relevant to its defense against plaintiffs' evidence or argument as to the reason why State Departments of Transportation took certain actions against X-Lite in an effort to prove its design defect claim.
Are you agreeing that it's an abuse of discretion standard by saying the court acted arbitrarily?
Your Honor, I maintain that the lower court's ruling resulted from the application of an erroneous standard when it required that Lindsay first prove what affirmative evidence plaintiff would offer at trial before it allowed Lindsay to discover evidence that would be relevant to its defense. But the lower court's action, I believe, lower court acted arbitrarily even under the abuse of discretion standard. It is also clear that the lower court misapplied the law when it required Lindsay to first prove substantial need without first requiring Mr. Durkos to prove that compliance with the subpoena would impose an undue burden on him.
With that, your time is up. If you just want to do a wrap-up sentence or statement, that's fine.
Thank you, Your Honor. Lindsay respectfully requests that this court reverse the lower court's decision and require Mr. Durkos to produce documents responsive to Lindsay's limited requests. Thank you.
All right, thank you both very much for your arguments. We will take the matter under advisement. We will issue a written decision in due course. It'll be mailed to both sides as well as posted on our website and that of the Supreme Court.